This is going to be a two-part video lecture dealing with family protection, chapter 8 of the book, dealing with certain rights a spouse has when the first spouse passes away, the rights the surviving spouse may have. In class, we've talked about the fact that you can disinherit a child. A lot of people think you can't, but you can. You don't have to leave them a dollar. You can disinherit a child, a child that is alive at the time you're doing your will, with the exception maybe being a couple states that make that kind of difficult. Louisiana being one. It's hard to fully disinherit a child, but for the most part, you can disinherit a child. It does get trickier to disinherit a spouse. Um, Essentially, state law deems a marriage to be a pretty important thing. If you pick someone to be your spouse, then you are committing to some state law requirements that go along with that relationship. And you kind of should. If you've picked this person to be with for the rest of your life, whether that turns out to be true or not, along with that comes some obligations that people need to know about, and you need to know that are going to come along with marriage. To understand those, you have to kind of back up for a second and know that we have two big picture marital right systems: the community property system and the what's called common law marital property right system, which is the bigger system, the more common system. For this class, for community property systems, all we really are going to talk about is this. It's statutory, it's state by state. There's about 10, 11 states that have community property. As an estate planner, you need to know whether your clients have lived there and accumulated property there, because it might be handled differently from their other property that they own that is not community property. And essentially, the statutes tend to deem both spouses as one half owner of the property, regardless of title. Title becomes less important, which is interesting because we focus so much on the wording of deeds, the wording of account titles. Community property does not focus on that. It says you each own half, regardless of how it's titled. So your will in a community property state, your will may govern property that's not titled in your name, that's fully titled in your husband's name or your wife's name. Your will, as the other community property spouse, might in fact govern part of that property not titled in your name. It's a very strange system. For me personally, as an estate planner that focuses so much on how title to property is held because of Alabama's not a community property state, it is strange for me to think that a client's will can govern property not in their name. But that's how community property works. They don't focus on title. They focus on more of a kind of an equitable ownership of the property, whether you're on the title or not. Um, and wills um, tend to need a little bit more care and need the expertise of a community property lawyer whenever you're dealing with a client that lives in a community property state. Which doesn't happen much for me. And if you live in a common law state, it might not happen much for you, but when it does, you really have to make sure you've gotten it right. If they have community property from a former state they lived in. Most of our discussion will be on common law property. Pages 256 and 255, 256 in our book are kind of the big picture definitions of those two systems. Um, because each spouse is not deemed to be the owner of property in a common law state, there are some state probate laws that come into play to help protect a spouse that doesn't have anything in his or her name when the first spouse dies. If the first spouse dies and everything's titled in his or her name, there is a strong possibility that the surviving spouse could get left out in a common law state. Doesn't happen in a community property state, but in a common law state, the surviving spouse could get left out. To prevent that, there's um, two concepts that prevent that from happening, that really prevent you from disinheriting your spouse. And one is the elective share, page 257. This is this share that a spouse is entitled to if they don't think the will has given them enough. They're allowed to do what's called elect against the will and take the so-called elective share, which is the state right share that a surviving spouse is entitled to. That's what I was talking about when you get married. State law deems that to be a pretty important relationship, and they're going to give you some rights. And one of those rights is the elective share right. So once you become married, then as a surviving spouse, you have an elective share right. Conversationally, a lot of estate planners call this the one-third rule, which conversationally just means a surviving spouse is roughly entitled to one-third of the estate of his or her deceased spouse's assets. That's an easy way to explain it in a meeting. The mechanics of that rule are where lawyers become lawyers. I mean, there is a detailed method to figuring out the one-third share that the surviving spouse gets, and it's not always a one-third share. Um, because remember, elective share laws are state laws, they're probate laws, so they're state, and they may vary a little bit from state to state. But essentially, you look to see when the first spouse dies, what did the will leave the surviving spouse? And if it didn't leave her, if it didn't leave him or her anything, then we know we've probably got an elective share issue. If it left them something, then we might have an elective share issue. And essentially, you have to kind of run the numbers to see, did the surviving spouse get at least what the elective share rule statute would have given him or her? And if they didn't, then the surviving spouse can elect against, say, I don't want what the will left me. I want my elective share because it's more. You typically would not elect to take the elective share unless it's more. Um, and it's a pretty sure thing. Um, a court is going to give the spouse the elective share, even though the mechanics of getting it are you have to petition the court for it. You have to go in and get it. But once you do that, you're going to get it, assuming the will did not leave you the full amount of the elective share. The all statutes are, can be a little bit different, but what you really focus on is you look to see what did the spouse get, what did the surviving spouse receive under the will, and is that greater or less than the statutory share that would have been given to him or her under the elective share statute. And some of those statutes, we're not really going to go into them, but some of them say, hey, look to see what does the surviving spouse have in his or her name. Are they the richer spouse? If the surviving spouse is the richer spouse, then sometimes the elective share provisions don't give as much to them. Sometimes they don't focus on how much does the surviving spouse have at all. It's not about that. It's what did the first spouse to die leave to him or her. So they're all a little bit different, and you have to read the one that's applicable to you and the issue that you're trying to solve to see what it exactly says. But essentially, they have this issue in common, and that is what assets go into the elective share calculation. Because up to this point, we've talked about different ways that assets get to people when you die. One way is it flows through the estate because you have a will. You have a will and it's going to flow assets through the estate. You don't have a will, intestacy is going to flow assets through the estate. But the only assets that that flow through the estate, whether you have a will or intestacy, are assets in your sole name that don't have a beneficiary form or a joint owner or some other way to get to the next owner, i.e., non-probate assets. So typically, the elective share applies to probate assets, i.e., assets in the estate. Examples of non-probate, again, just for a reminder, insurance policies, 401k plans, trust assets that are governed by a trust and not the will are not probate assets. And sometimes those can be big assets, life insurance, retirement assets. Those can be big things. And so if your elective share statute starts from the base of, hey, figure out what was in the dead person's estate, and that's what we're going to calculate the elective share from, there's some potential problems because a dying first spouse to die, a person who is married and is dying and is the first spouse to go, they can engineer how much is in their estate. How do they do that? They make assets joint to somebody other than the spouse. They change the beneficiary form from the spouse on the life insurance to someone other than the spouse. They change the retirement plan beneficiary from the spouse to someone other than the spouse. So there's ways to engineer how much is going to flow through your estate if if you find yourself in a position of wanting to engineer that. What kind of person would want to engineer that? Probably someone that's unhappily married, probably someone that's maybe filed for divorce but not divorced yet. Because elective share, the nice thing about it, it's one of those black and white rules. You're either married or you're not. And if you're married, until the day you're not married, the elective share applies. So it's not terribly uncommon for somebody who has filed for divorce, or been on the other end, been in a marriage where the other spouse had filed for divorce, and have questions on, hey, how much do I have to leave my spouse now that we're on this path to divorce? And the answer is, well, you don't have to leave them anything, but they're going to get the elective share if you die before you get divorced. So don't die before you get divorced. Once you get divorced, elective share is off the table. And the Thompson case, page 259, is kind of a good example of how people try to engineer or manipulate the elective share statute and what a spouse gets. It was a case where you had a couple who was married in 2001, and the husband died about 10 years later, 9 years later in 2010, and he had substantially more assets than the wife. And he funded a trust with assets that equaled about 5.8 million. A trust is not a probate estate. A trust is its own thing that we'll talk about in a couple weeks. Trust, the will doesn't govern the trust. Intestacy doesn't govern the trust. It is outside of the estate, probate estate system, and it had about 5.8 million in it. Um, the and in Arkansas, where this case happened in 2014, the elective share would have been roughly one half of the stuff. Um, there was a trust with 5.8 million, and then there was an estate that had about 230,000 in it. So all in, half of those two numbers was about $3 million. The elective share would have given the surviving spouse roughly half, $3 million of the decedent's stuff. He didn't want that to happen. So he did a couple things. Um, he executed a new document shortly before his death. That's where the trust came into play, and left her out of the trust, did not provide assets for her, and left very little in his estate. The roughly 200 and some odd thousand was in the estate. So when she went to get the elective share, she filed her petition, and she was opposed. Other beneficiaries of the trust said no, she doesn't get this because it's trust assets, not probate assets. She fights for her elective share, saying, and she wins at the trial court level. The trial court, middle of page 260, says that um, assets of the trust would be included in the decedent's estate. So they're effectively moving trust assets back to the estate for the limited purpose of calculating her elective share amount due to her because of the decedent's intent in amending the trust in 2009 was to deprive her of her marital rights to his property. Um, that's what the trial court said, and then the losers appealed, saying, "I hear all that, but the statute says look at the estate, not the trust, to figure out the elective share." So it's a pretty valid appeal, and so this court essentially cut to the ending, saying the trial court was not clearly erroneous in its decision. And so they're almost kind of creating a little bit of an exception to you only look to the estate when there's this bad behavior in trying to intentionally defraud, but not legally defraud. The court talks about that in a minute. Fraud in the conversational sense, when you're trying to defraud your surviving spouse over his or her marital right property. And they go through these facts where, hey, look, when they got married, he treated her well. He um, she had a great lifestyle. There was no reason to think he didn't want her to have a great lifestyle. He wasn't always holding his stuff back. When they were married, he shared stuff with her. It wasn't until he got sick and sort of stopped doing that, and she didn't have a way to live, that she kind of had to file some court action to get some support from him, even though they were still married. A little um, that had to be a little awkward at the house. And then that, of course, just drove a wedge further. And that's when he's like, "Hey, we're married, but you're not getting anything you're not getting much of anything when I pass away." And that's when he started taking things away by revising the estate plan. And so the court liked the fact that, hey, you used to treat her well, and you used to share property with her, but now you're not, and that doesn't feel right. You shouldn't be able to take advantage of the elective share statute that way to deprive your spouse of his or her marital rights. In fact, bottom of page 261, one of the things we've kind of the themes we've always talked about in this class is that a testator should have freedom to distribute his or her stuff the way he wants, with some guardrails here and there. But the court kind of focuses on that. While it is true that a testator can devise his property however he chooses and can exclude or disinherit his spouse, the testator's choices do not prevent the surviving spouse from getting his or her elective share. That's going to be this fundamental right a surviving spouse is entitled to. And the loser in this case was trying to say, hey, to get around it, you got to prove fraud. You have to prove that the statutory tort of fraud in order um, to to prove that he was trying to do something um, untoward and get around the elective share. And this court says, no, we don't. Um, Fraud on the marriage is not fraud in the legal sense, and we don't she doesn't have to prove all the legal elements of fraud to succeed to get around the elective share. They're more focused on if there's bad behavior that amounts to this conversational fraud on the marriage, fraud on marital rights, then that's going to be a big factor in her winning. And it was. So basically, the holding was once the circuit court determined that a settlor had the intent of depriving his or her spouse of marital property rights when creating or amending the trust, the effect of that intent is to have the trust assets included in the estate for purposes of calculating the elective share. So that's a very kind of equitable way to approach it. You can't do bad behavior and take advantage of the wording of a statute. Although people do it all the time. I mean, the wording of the statute is the wording of the statute, and if we want to word something differently, it should be drafted in a different way. In Alabama, we have a probate estate elective share rule, and there is this. I've had clients come to me and say, "Hey, we're separated now, or we're getting divorced. Um, I don't want my spouse getting the bulk of my estate. The will at the time might say he or she gets all of it. Well, that's not the case anymore. How do I not leave anything to my spouse?" Two issues come up. One we'll talk about later in the class, an ethics issue. If I represented both spouses, I can't help you. I cannot represent you to take assets away from your spouse because you're both my clients. Um, but the other issue that comes up is, hey, look, there is no sure way to take assets away from your spouse until you're divorced. There is this possible way in Alabama of moving some of your assets to a revocable trust, kind of like they did in this case. And those assets may get around our Alabama elective share rule, but um, there is no case that says that works. Um, there's no real case that says it doesn't, but there's no real case that says it works. So basically, what you tell people is you can do it. We can try that. At a minimum, the surviving spouse is going to have to come in and kind of fight for the assets, but I can't tell you it's going to work. In Arkansas, it doesn't work anymore, but we haven't quite come that far in Alabama to make it clear whether it works or not. But it's a weak technique, and you have to disclose all kinds of things to the client that it probably or may not work. But it's something you can do to try to get around the elective share rule. States that see this is a problem, where the statute limits it to figuring out what's in the dead spouse's probate estate, have addressed that problem with what's called an augmented estate approach, which I kind of like. Page 263, 264. And the augmented estate approach, the UPC approach, is a more modern approach to elective share rules. Middle of page 264, you do a couple steps. The first thing you do is determine the value of the decedent's net probate estate. Starting point is the same place because remember, the decedent is the first spouse to die. Figure out their net probate estate. Two, the value of decedent's non-probate transfers to people other than the surviving spouse and non-probate transfers to the surviving spouse. So we're looking at two things. Hey, spouse, you may have gotten some stuff. You may have gotten some stuff non-probate wise because your both names were on a deed or both names were on an investment account, and you couldn't change that without two signatures. So we're going to look at what non-probate things went to other people and what non-probate things went to the surviving spouse. The theme is we're looking at everything. We're looking at decedent's probate estate, non-probate transfers to people other than the surviving spouse, non-probate transfers to the surviving spouse, and we're also looking at these, this is interesting, the surviving spouse's comparable assets if he or she had died first, i.e., what do they own? You're looking at that too. The theme is you're looking at the whole picture of this marital relationship property, and coming up with what does that look like? What does that pie look like? What all's there? That's the first step. And then the second step, middle of page 264, is you then apply a pretty black and white percentage to that pie to figure out what the surviving spouse should get. The longer you're married, the bigger the percentage. I think the book gives you the far end. Spouses who have been married 15 years or more get the full elective share, which is what you think it would be, 50% of the augmented estate, or what I call kind of the augmented pie chart. So if you're married 15 years or more, the most you can ever get, you're never going to get more than half in the augmented estate approach. But if you're married 15 years or more, you can get half, which is the biggest share of an augmented estate. I like that approach. I think it tends to be a little more fair by looking at everything, both the decedent's assets and the surviving spouse's assets. And then the percentage is just a sliding scale. The book doesn't tell you what it is, but you'd have to look at each state statute. But it might be if you're married for 1 year, or 2 years, or 3 years, you get, I don't know, 10%, 15%. If you're married 8 or 9 years, you get like 25% of the augmented pie. So it just kind of, the longer you're married, the bigger the percentage gets. There may be some inequities there, but um, but that's it. By definition, it's got to be kind of black and white. You can't just say if you're married 7 years and you're happily married, then you get a different percentage than you're unhappily. You can't inject subjectivity into it. Um, so if there's a flaw, that could be a flaw in the